we should. Hello, we should be on.
I think we are.
Excellent. Okay, we're going to give it a couple of minutes before everyone gets there.
5 minutes of small talk.
Oh, well, we can do it 5 minutes.
What are you going to small talk about today?
We're going to talk about how we've both got fidgets, which we both enjoy. So one of our staff members has got a 3D printer, and her partner is on extended leave at the moment, and he's been making fidgets for us, and we've all become a little bit obsessed.
I know, we have become obsessed. We've got many different types. We don't pick the quietest ones for today.
Yes, we picked the quiet ones.
In corporate colours with the HR Dynamics wording and phone number on them. So we could maybe raffle these off like this.
If anyone wants it, you put in the comments that you want one of these, let us know.
And so we're paying them.
We'll pass them on. No, they're beautiful. We're going to get some made up so that we can use them when we do training sessions.
Yes.
And,
not you as the trainer. I'll
be standing at the front of the
put it down.
So I was even driving home last night. There was one beside me, and I just wanted to pick it up and play with it. It's got this that goes round and round in the bit.
Yes.
Anyway.
Small things amuse small minds.
Small things that exactly. What else has been happening, Dee?
Other than the rain and the coming to the realization that we are in February next week.
I know, 2025. So Sam Harrop, who is a business coach, who we work with sometimes, says that Australia business community, particularly up north, closes down from Melbourne Cup Day, and it doesn't really crank up again until Australia Day. And I have to agree,
Does that mean I can take leave from Melbourne Cup Day to Australia?
No, we all hobble through and we do a must-do list through till December, and then we will start waking up from January, which is a business owner I find quite frustrating. I'd rather it's just consistent all the way through, but I'm super pleased to say that we are through Australia Day now, and people are back at work,
back at school,
back at work. People are focused on the year ahead, which is good. God damn it, get rid of all of those public holidays.
I say bring them on, more.
I don't like a public holiday, and Easter this year is just a nightmare.
But it's the same as every year.
No, because it's got Anzac Day attached to it, so you're going to have staff going, we have an extended time off, and they're away for like 2 weeks. You know what that does to productivity?
I know, but see, then you have Seek actually putting out the promo material in January, how to maximise leave.
I know.
So I was going to.
I don't share this. No, don't share that. So yes.
But you could say, yes, I could have those days, and I have all these witnesses to say that, yes,
definitely
I could have those days off.
Definitely. No. Yes. No. So,
and
the interesting one that came in today, we had a client who asked if a staff member had used up all their sick leave, and another staff member said, "Can I gift that person my sick leave?"
Yes.
I said, "No, you can't."
See, I say yes, you can.
Oh, you cannot.
Well, it's not provided by the Fair Work Act, but if the employee is wanting to, and you have robust documentation in and around the consequences of it, it's doable. Would I recommend it? Probably not. Starts to create a customer practice.
And then you start, you could start paying people to sell off their sick leave. It's fraught with danger.
Oh, absolutely. I'm not saying it's not. But if the question is, can you do it?
Well, of course you can do it, but yeah. But no, please don't do it. Please don't do it.
I've worked with clients that have done like almost a what would you call it? Like a pass the hat around essentially to collect leave for one of their co-workers who had a seriously ill child.
Yeah. Which I can see that from a compassionate ground when it's very limited, but
so
I would prefer the person goes into negative accrual.
Yeah, look,
because you can't cash out personal leave either. So it wouldn't stand up in Fair Work in any way, shape, or form. So
no, it wouldn't stand up, but you've got to assess the risk as to what you want to, I guess, achieve and what the motivation is behind it.
Yeah, exactly.
The biggest risk is that the relationship between the two individuals turns sour, and then it turns into a "you stole my sick leave" argument.
Yeah.
Yeah. We can do it, but would we do it?
Probably not. No. Anyway, so 2025, welcome. to everybody who is joining with us today. So then I'm going to go through what we are seeing as some of the hot issues in 2025. If anyone's got any questions, please just pop them in the chat room and we'll have a look at that at the end and answer the questions for it. So
Can I put it this way?
Yeah,
you know, I'm big on disclaimers. These are just our projections based on, I guess, our experience. Chewing fat. Depending on your organisation, your maturity, your size, your scope, your locations, internal, external resources, you know, you may have some other, I guess, predictions that you're seeing for your workplace. So whilst this is sort of our list, it's by no means extensive.
And let's start off with election.
I love a good election.
Yeah, so election. So how's that going to impact us?
Well,
on the ground.
On the ground. Usually what we see historically is that if we have a change in government, we are likely to see the new government want to put their stamp on the framework and the legislation. So it usually has this sort of pendulum effect. New government, new rules, some of those rules will out or undo what the previous government has done, some will add to, and then some will extend on. So pretty much I think if there's going to be a change in government this year, and I'm not saying there will or there won't be, that's a whole other subject matter for debate. If there is a change in government, we are likely to see some significant changes. Where they will be, don't know.
I actually think that we will be impacted with this in 2025 is that Labor does align itself with the union, and Dutton is leading quite a conservative government, and potentially there's going to be media union bringing up things about employers doing the wrong things and entitlements. So there's going to be a media storm around it, the campaign and a media and all these stories and things happening, which then creates staff asking questions and, oh, this is happening to me, or is this actually an entitlement that I should be getting? So I actually think from actually on the ground how you will be impacted, you are going to be, in my crystal ball, I think you're going to be impacted by the media stories that then go onto the social media stories that then get picked up by some of the staff and cause a bit of distress. I actually think if there's a change of government, we're actually not going to see any significant changes in policies or those things until next year at the earliest with it.
We might get an indication of what those changes are going to be and whether or not that's going to be significant or not.
But there'll be a few things that start to come out and people go, oh my gosh, I'm entitled, or you're not allowed to do this, or I should be getting that, or this industry pays this amount of dollars, or whatever it's going to be, which is often not entirely correct.
What's in the media is not correct.
No, I know, shocking. Yeah. So there's a little bit of sense. I'm trying to say sense.
No, I can't say it.
Yeah, you know what we're talking about.
Yeah,
they've sensationalized it.
Sensationalizing.
Yeah. So that's something just to watch and to be aware of and could happen. Next one that I wanted to talk about was moving from like a 5-day week to a 4-week flexibility working from home. This is still going on from COVID. I feel we've sort of this is still really a bit of a hot topic that we're seeing. We've already had a call this year from a client that wants to move from a 5-day to a 4-day week and asking what that looks like. What are your thoughts?
Look, I certainly think that flexibility and modification of the traditional way that we do work and the working hours is going to become more prevalent. Absolutely. I think that we did learn a lot from COVID. We also learned a lot of probably what not to do in terms of working from home and now bringing people back into the office. But I think that the need for consideration of flexibility, particularly not one size fits all, is going to continue to be a key driving factor right through from recruitment through to the employee life cycle, and then the end of the employee life cycle or the termination. And if your organization is one that is, I will stick to the traditional model, we will work 7 till 3, 9 to 5, whatever it is, Monday to Friday. That's how we've always done things, and that's how we'll continue to do things. Potentially you're at risk of being left behind and potentially losing some talent to other organisations who are offering flexibility or offering compressed working weeks.
Yeah, I think you have to have a really open mind. I'm not saying that flexibility is appropriate in all situations. Not all jobs can be work from home, and not all jobs can be part-time or occasional or whatever, but certainly it's something that you need to think about. So that's one. The next one that I had on my list was evidence that of compliance for the sexual harassment training. And so when we had a look, that legislation wasn't last year, it was the year before, I think, wasn't it? 2023 that legislation changed. So maybe just run through what that legislation is, because we still have employers that don't understand their obligations for that, and where you think it's at.
Yeah, it's certainly becoming, I guess, a hotter topic, and I would have thought it would have died down by now, but it seems to be
heating
ramping up. And in a nutshell, what the legislation did back in 2023 is it came off the back of the Me Too movement and some maybe events that happened in Parliament that may have triggered some reevaluation of what we do. But in a nutshell, it basically said that the employer has to be able to demonstrate that they are taking a positive duty of care in sexual harassment, meaning that essentially you need to have a standalone policy. This is the things that they're looking for in terms of compliance and executing a positive duty of care. A standalone policy. So if you still have a policy that is bullying, harassment, sexual harassment, and any discrimination, quite common, you need to be doing some work in separating out those policies. There needs to be a documented and executed training plan for sexual harassment in the workplace, and that includes sexual harassment at the ground level and also for managers and supervisors. There needs to be a distinct difference, and we need to be educating managers and supervisors of their obligations of what they need to do in terms of addressing and managing sexual harassment. And it's not just a tick and flick, yep, we've done the training, thank you, we're compliant, see you later. They want to see evidence, and when we say they, we are talking anywhere through from workplace health and safety, so that being subjected to an audit through workplace health and safety through to the Fair Work Commission. They want to see that it is a targeted, proactive approach to make sure that your workforce is educated on what is proper and not proper in terms of sexual harassment. The other addition was sexual harassment was included in the definition of misconduct under the Fair Work Act. So it is right up there in terms of consequence when we're talking about theft, assault and fraud.
So serious misconduct with it. So we've had several businesses that have been audited from workplace health and safety, and basically they've just been sent a letter to say, we're going to be coming out to your organisation and we want to see your policy, we want to see evidence of training and what steps you've put in place to ensure that it's a safe workplace. It comes under the psychosocial safety as well. With it. So in businesses, I think the businesses that we've who have had this happen, I think one's got less than 5 staff, one's probably got less than 20, maybe 20 staff. So it's not only big businesses, it's also small businesses. Everyone thinks, oh, this doesn't apply to us. Interestingly though, whenever I've done training to a group of employees, 9 times out of 10, I will have generally a female come forward and say that they have been subject to some sort of inappropriate behaviour, language, it could be touching, it could be just the way they're referred to in the workplace, or blatant sexual harassment. So it's a big one, you know, it's legislated. You have a legal responsibility that you have to conduct this training and you have to have those policies, and it's not a second forget. It's going to be every year you need to make sure that you do that. So I think that's a really important one. Interestingly enough, the statistics that HR Daily put out the other week was majority of sexual harassment claims are male to male. Oh, really? Yes. So, and that stems from potentially differences in generation gaps, you know, like, oh, you know, don't be such a soft, whatever, and comments being made that potentially were acceptable 20, 50 years ago, still being manifested in workplaces, and most of them male to male. Can I add on
question
Go.
to your sexual harassment and our predictions for 2025. My predictions for 2025 is that where we have a disgruntled employee, however we have a disgruntled employee, whatever has happened to get there, the level of, don't shoot me, vindictiveness, if that's the word, where an employee feels that they have been hard done by for whatever reason, employees now are going to larger lengths to lodge complaints, and not just in singular jurisdictions. So, you know, if there was a termination, there was an unfair dismissal claim or potentially a general protections claim. What we're seeing now is there are stop bullying claims being lodged when they're still in employment. There is complaints being lodged with the likes of Workplace Health and Safety or the Human Rights Commission. So the degrees of trauma for employers, I think, is going to extend.
I think what happens is that departments have been, Fair Work and Workplace Health and Safety are being very proactive in making sure employees know their rights and where they can lodge their complaints. And so someone's got something wrong, they go, oh, I'll lodge to them and them and them and them, and it doesn't cost them anything. They're able to put it through, and then literally you've got an unfair dismissal, stop bullying, and you've got a workplace health and safety investigation. It's all coming from the one staff member who left last week. But and employers, we have seen sometimes downplayed and go, oh, it's just a storm in a teacup, it's nothing, and they don't do like a proper investigation. They sort of minimize it in some scenarios, and then it just starts to become bigger than Ben-Hur as a result of them not taking it seriously. So it's it is, you're right, we're seeing a real pattern in that starting to happen, which is causing some pain for employers. You really need to get on top of it. And look, just because I've put these complaints in, it doesn't mean that they're going to be upheld or there's going to be consequences in it. You know, they may just, you may not be penalised, you may just be given a notification action that you need to implement a policy and demonstrate this training in a time frame that it needs to be done. They can provide penalties obviously for it, but often they're more on a corrective, particularly workplace health and safety, rather than a punitive one.
And I would like to, I think my experience with the Fair Work Commission this year, in one matter that I've had, that in particular, I've seen a very different shift on how the Fair Work Commission dealt with this one particular matter. And I'm hoping it's a sign of the Commission having a bit more of a tangible approach. And what I mean was this client that we were working with started with a stop bullying claim. There was some performance issues that was being addressed, very long, very complicated, complex, extended out over many, many months. And we were in the stop bullying claim, and the Fair Work Commissioner said, pretty much, it doesn't look like this relationship's going to be tenable. What are we going to do to resolve it? And we walked out of there with a resolution of employment. And I would ending employment by deed of release. And I would never have actually contemplated last year that the Commission would go, hey.
Is that something that is across the Commission where you just lucky passionate on the day?
It's kind of latch on to some hope.
You do know, depending upon which commissioner you get, or depending upon what sort of outcome you get.
I'm hopeful that maybe 2025 it's going to be a bit more
in their approach with it. Absolutely. I sort of leads into something that you brought up yesterday, in that we're seeing the generation change, and so some of these complaints that were coming up, it's like, you know, an older guy that calls everyone darling, and everyone's accepted it forever, and then you get someone who's coming and they're like, that is just not acceptable, and then they're lodging a complaint, and it's like, oh my gosh, they're overreacting, and it's a tricky one.
2025 is predicted to be the year that I always get them wrong. Gen Y comes after Gen X, yes? Yeah. So Gen Ys and millennials will outnumber Gen Xers and baby boomers in workplace. So if you're looking at how, I guess, your team culture is established, the demographic of your workplace, if an employer is not doing appropriate engagement, and that is going to look very different for every employer, to bridge the generational gaps between baby boomers and Gen Ys and millennials and what's alpha, beta, gamma, kappa, I'm not quite sure what comes after that. When we have these different demographics coming into one singular workplace, there needs to be a lot of concerted effort to educate people on the differences in tolerances, differences in experience. Just because a baby boomer has always been brought up of, you know, either put up or shut up, and this is just the way we do things, and that's it.
Follow hierarchy,
etc. That's not right or wrong. A millennial comes in, they've been educated, and their life experience is completely different. They're not right or wrong. But unless we can actually encourage a team culture where these two different demographics and everyone in between can embrace the fact that we are all different and we are all bringing something to the table, we're likely to have some friction. And what I find really, really interesting is that, you know, people are the first to say, we're very inclusive, and you know, we know that we shouldn't do things that exclude people and potentially family orientated until someone has a different perspective to our own, and then we automatically go to the you can't do that, you're wrong, I'm right, etc. And I find it very bizarre.
I think that's a really important one, and definitely something that we are seeing, and how you handle that, particularly around the whole sexual harassment and complaints and everything like that, and the generational different, and
particularly if your managers are of the older generation, and if we're not equipping them with the ability to change their management styles or adapt their management styles to manage some of the younger generations, we are.
Something as innocuous as someone saying, oh, for God's sake, just pull your head in and get back to work. Bullying claim. And you're like, guys, like, seriously? Like, and you know, but those are the types of crazy stuff that we're starting to see. So you have to just be very, very careful around that.
Careful and proactive.
So I'm sick of talking about casual conversion, but we've been talking about casuals forever, but I still think that it's something that well, there's a different part of it that I think we need to look at for the casual, because I think people know quite a bit about the offering the conversion now, and if you don't know, you should. If someone is working, well, the legislation has changed, hasn't it, to you as an employer having to offer the casual conversion if they've been regular and consistent for 6 or 12 months.
No, it's gone the opposite way.
I know what's changed now, it's gone the other way. I still say that as an employer, you should be offering it, because there's nothing to protect you if suddenly an employee says, oh no, but I asked for conversion and you know they never got back to me, or they never responded to me. Whereas if you've actually sent them an email or a letter or something, it shows you're proactive. I still think as an employee you should be proactive. But that aside, my concern, and I think the really sticky area, is about the assessment of their role at the beginning of employment.
Yeah, and look, I think that, you know, there's no point denying that over the past probably 4 years, I'd say, there has been what could be described as a progression towards eliminating casual employment.
Or attempt to.
We're not going to be able to.
We know the cases. We know the unions and labour, you know, prefer the stability of a permanent employment rather than casual.
Absolutely. So we're seeing these changes in legislation that are supporting that agenda. Potentially, if there is no change in government, we might see some further progression on.
Or we might see one.
Tightening up on casuals or not. But I think that the point that 2025 will bring is the employers, there's going to be that heightened awareness that it's not just about the casual conversions once they're in the workplace. It's the obligation and the need for the employer to be able to assess, or having to assess, right from the get-go. So I've got this role here, I'm looking at this piece of paper, this is my job description, I have an idea that I want this person to be in my employment or in the role 4 days a week, and I need them to do 30 hours, and I need them to do, you know, 7 till 4. That's what I want. And I guess any HR person or any payroll person would look at that and go, okay, well, you've already got a regular and intent in your mind as to what sort of does this person look
hours.
like. So the assessment of that is not a casual role. So the days of saying, oh, we'll just start them as casual and we'll just see how they go. And look, you know, as a parent, my eldest son, bless his cotton socks, still working casual 3 years later. And I'm like, you can't say anything, it's not your role. I bite my tongue and I shut up.
So I guess
We
what
need to move on.
I guess it comes back to the biggest risk in your employment is like an airplane when you take off and when you land, so when you start. So the example that I would see happen is that you have a new employee who's starting, you offer them casual and you offer them consistent hours, days of the week, certain hours that they're working as a casual. They've been working with you for 6, 7, 8 months, whatever it is with it. The relationship gets a bit tense for whatever reason. And that employee is now looking at what ways they can have
just cause trouble,
cause
cause some
money,
angst because they can
show that you're not a good employer, whatever. They potentially could lodge something with Fair Work to say that I should never have been employed as a casual. I should have been employed as a permanent staff member. It's never been a true and casual relationship that you've had with us. And you know, then potentially it could come down to you have to give them annual leave and etc. Now I know you will have given the casual loading and it would be argued that, you know, that was on the pay slip, it was in the contract, clearly they were given a separate loading. But I just think that if there hasn't been a conversation where they were offered the option of permanent, that's an issue. That could come back and bite you. And I do think that, you know, there's some employers that are like, but everyone else is casual and they want the higher rate. And I'm like, that's fine, but you just need to have a conversation with that person to say, these are what the hours are going to be. It's a part-time position. If you prefer to be casual, this is what the rate is. And you at least show that you gave them the option for it.
I have one better.
Yeah.
Have one better. I guess I think that there is still the legislative governance on double dipping. So whilst they may not have an issue in terms of you paid the casual loading, the annual leave, etc., but it's probably more going to be apparent in terms of things like the casual employee being able to apply for unfair dismissal claims, claiming notice of termination, redundancy, etc., where I think is probably the
sticky one.
The sticky ones, because that's not covered by a casual loading.
Yeah.
Right. We did some work with some clients last year, proactive, it was great, where we developed a very, very simple template, which tried to deal with that exact issue, because they came in and they said, look, we have these employees going, I want the money. And I get it, you know, the cost of living, you know, crisis, all of those things. If you're saying to somebody, look, we can give you part-time employment, but you're going to lose 25%.
The flexibility to know they can ask days off if they want them.
Yep, that's right. So the conversation is really important to say, look, here is the offer of employment. We can offer you part-time here on,
and this is what it looks
$30 an hour, 30 hours a week, We can offer you casual on $45 an hour, And you know, we give them some time to think about that. We then have a pro forma template that says, you know, I have been offered this role in a part-time capacity. I am electing.
Yeah.
And I have requested to take this role in a casual capacity.
I think we're going to see the need for more of that happening. So I think some employers freak out because they like casual and staff aren't casual. They're like, oh, they're forcing us not to. That's not the case at all, but it is making sure that you offer the option of permanency to your staff.
Is a permanent role from the outset.
Yeah, definitely. The next one that we saw come through just before Christmas, wasn't it? Was the criminalisation of wage theft. Was it just before Christmas? Is that earlier?
No, part of me actually wants to say, was it early this year? Anyway, it doesn't matter.
Yeah. Anyway, you can go for prison.
You can go to jail, pretty much. And I think this is a really significant move. In line with, you know, the criminalisation, industrial manslaughter legislation changes that happened a little while ago.
Workplace health and safety.
Through workplace health and safety. Basically, the wage theft legislation is talking about if there is a malicious or deliberate attempt to not pay wages entitlements that an employee is owed under a piece of industrial legislation or industrial instrument, modern award, enterprise agreement, then you can be prosecuted and you can be prosecuted in the criminal jurisdiction. Go to jail, criminal record, everything else. But what I also think is important is that, you know, HR practitioners, payroll practitioners, the same onus is actually on them.
Yeah.
So if they have a part in or are complicit in underpayment of employees, it's not just going to be the owner of the business that potentially goes to jail. It could be all and sundry who have had a finger in the pie in this deliberate underpayment. Really important though that when we talk about deliberate underpayments, we are not putting the fear of God into people, because we know that genuine misinterpretations happen quite readily under the award. Intent, you know, things with flat rates and calculations of
let's face it,
all-inclusive salaries.
The vast majority of underpayments that we see come through here, and we see a lot come through here, organisations that haven't been paying correctly and having to do back pays or work out rates, the vast majority is a genuine mistake. They're misclassified, they haven't understood or interpreted. Now that's not, it shouldn't be an excuse, but it is a reason. Like they haven't maliciously tried to do it. And I don't think those people are going to be going to jail. You know, at worst, they may get a penalty depending upon the severity and situation.
If the penalty, don't address it, don't fix it.
Yeah, absolutely.
Then yes, they will go to jail.
My concern is, because I think everyone, hopefully, that's attending this, you know, believes and are proactive in ensuring they're paying their staff correctly. It's some of those grey areas. So, for example, I know that there's some employers that they don't pay overtime to their staff if they don't have breaks. So if you don't get a break depending upon the award, it's either usually 5 hours or 6 hours. You should therefore go on overtime, and the staff are quite happy to work through. It works for their employer. Maybe it's a retail and they've only got one person, so there's not an opportunity for them to go. So they are not paying that penalty, and the employer's happy with it and the employer's happy with it. Some of them will pay them an extra half an hour at the end of the day, like as a paid break sort of scenario. But that potentially is a known underpayment. It's a dangerous area.
Yeah, I mean,
if an employee really wanted to push it, that they could actually really push that, and a good lawyer could really go to the employer, because they could say that you knew this was happening, it wasn't a mistake.
Yeah, absolutely. I think that where workplaces have got known areas where they're not really complying, and there could be 100 reasons why.
And some very good reasons why. And retail stores are a great example. You know, logistically, it's really tough, and there's no one in the shop between these hours, so you can have your lunch, you can have your break, but if someone comes in, essentially you aren't working.
Yeah. And look, I think that there's always going to be considerations given to the environment that the employee is working in. And I think once we get some test cases on what wage theft sort of actually looks like, and we start to get those first convictions, particularly through to jail, that's going to give us a bit more of an indication of how much leeway the employer is going to have in terms of cooperation, for rectification, etc.
The other thing I think is that in those scenarios, even though it's probably not the correct use of an IFA, it's something's better than nothing. So don't just put your head completely in the sand. I would be wanting to have something so that you can say, well, we did consult, we did discuss, yeah, we weren't applying it correctly. You know, there may be some sort of back payment that you may still have, but at least it's not going to be malicious and with intent.
Yeah, deliberate intent.
Deliberate intent, so the employee agrees. And you know, let's face it, there's two ways that things come to a head with Fair Work. One is when there's just a random audit that's conducted and something's picked up. And the second one is when you've got an employee that goes to Fair Work and says, I don't think I've been paid correctly, and they ask for an assessment of what their wages have been. If you've had some sort of an agreement with a staff member and they've signed something, they're far less likely to go to Fair Work and say, oh, I've been underpaid, because they have not only entered that. So you've got, you know, less of a risk of it coming up, I guess, absolutely, as a result. But yeah, something to have a good think about. The next one is, so there's some interesting cases that came up last year where we had some employers, quite large employers actually, who were relying on policies that they had in place as to terminate some staff because staff had breached the policies. And the commissioner kind of laughed in their face about the policies.
Yeah, it's not a tick and flick.
No, so a policy, we're not saying that you shouldn't have a policy, but you need to show that policy is alive.
Something to that. If you have policies that you do not have, at least an annual or buy-in review on and are looking at them, then you shouldn't have a policy.
Yeah, it's almost more dangerous to have one, isn't it?
Yeah, absolutely.
Yeah.
Policies are great. We're not saying that policies aren't, but if you are not regularly reviewing and making sure they are still fit for purpose, then there is no point in you having that policy.
Yeah, and we see people get caught up too because they have policies to say, you will be given a 3 warnings or a probationary review and then an annual review thereafter every year, and then you don't do it, and then something goes wrong and they're like, well, you didn't follow your own policy with it. So what you have in your policies, you need to make sure you follow through on it, and then we would be looking at some evidence to show that you're rolling it out. So that's why, any of you that are clients with us will know that we are huge fans of the employee handbook. It's a really easy, concise way to distribute information. And it's something that can just get sent out on an annual basis for all staff to show these are the policies,
Yeah.
And or to have some sort of proactive approach where, January, February, March, April, where at Toolbox Talks, you just go through a couple of policies. And it's not, it's not an hour stop work meeting. These things can be done in, 5-10 minutes, just a reminder. If they want more information, go back to the policy. Yeah. But we want to see that there's some sort of proactiveness around appropriate behaviour, particularly, if it's, how you should be, if you're wanting to terminate because of, how they have handled customers or some of their behaviours in the workplace, so that goes against our values, our policies, our principles for the organisation. Well, if you're not showing that clearly that this is something that you are promoting, then you shouldn't really have it there. Absolutely.
And I think that employees are becoming potentially a little bit, we'll use the word smarter, to say that, they're aware of these policies, and where employers are not following the policy, they will jump. And some of the clients that I was working with towards the end of last year and some of these more complicated performance improvement processes where the employee has been put on a performance improvement plan, what we've found is that there seems to be a bit of a gap between employer policies that they do have for disciplinary procedures and managing performance, and not many of them talk about what happens when an employee doesn't complete successfully a performance improvement plan. Right. What do you do? So there's this gap. So people, they're going, okay, well
that's when termination of employment may occur.
That's right. But if you haven't, this one client or had a provision that counteracted that in their disciplinary policy to say that termination couldn't occur if warnings hadn't been given.
Right. So they trip themselves up.
So they have to go from a performance improvement plan to a warning, then to termination, even though they may have been on this performance improvement plan for the last 12 months.
Right. Yeah.
So it's really knowing how your policy relates to everyday interaction.
And sometimes less is more.
Oh, absolutely.
Yeah, you've got more flexibility.
Yeah.
Right to disconnect. We heard a lot about that last year.
Yeah, I think it's still going to be pretty much on top of the radar. Because look, I think there was a lot of media sensationalization. That's not it, is it?
Well, I think it's close.
It's close enough for today. It's close enough for January. Where there was a lot of media attention, and I remember driving to work and I'm going, so people are hearing this and believing that this is what the legislation is designed to cover. But the right to disconnect is not about the employer not being able to contact the employee after hours. It is the expectation of the employer on the employee to respond to that. So I think, the media did blow it way out of proportion. And created this bit of a scare campaign about, if your employee finishes at 5 o'clock, you cannot contact them. That's not what it's about. So I think that the employers are going to have to do a bit of education if they haven't already. You know, small businesses, the right to disconnect stuff doesn't come until the 26th of August. Don't quote me on that, August 2025. So you're going to need to do some education with your employees about your policies, if you have any, or your handbook, etc., or what right to disconnect looks like in your business.
I do think
So you can't email me after 5 o'clock and before 8. That's what the ratio said.
There's a little bit about role modelling that information too, because I have worked with some organisations that I've gone, yes, right to disconnect, and people don't have to respond, but you know, they are sending emails from, you know, 5 o'clock in the morning, and you know, they're doing work and commenting on things, and the other managers, so it's almost like it's the policy is there, but the culture doesn't support it, because everybody does. And then if you're the one employee or manager or supervisor or whoever that's not actually responding, then you sort of become isolated or potentially, you know, bullied. So
or treated differently.
So you know, it has to be followed through. And some organisations have done things like to set it up so that, you know, emails can't be sent, or you know, there's a thing that you can, because some people I like getting up early and writing emails. It works well for me. If I was a considerate and nice employer, I wouldn't have sent that to you, Dee. I would have it automated to get here at like 7:31. So it's 1 minute after you get it, work will be.
But yeah, I agree. It needs to role model behaviour. We can't.
Yeah, it's not just a policy. It's actually
so much of this stuff can be lip service, and I think that's potentially where we've got the capacity to come on.
See a bit of the changes. We've got a question that has come up here as to what happens if the employer doesn't follow their policies. Is that a Fair Work Act violation?
It's not so much an act violation, however, you have to look at the situation. So if you had a policy, say, for example, in relation to a disciplinary procedure that said, you know, your employees would be given 3 warnings, then termination. If you had an employee that did something that you felt warranted termination, and you didn't go through your 3 warning process, so therefore you haven't followed your own policy. If you're in a situation where that employee then lodged an unfair dismissal claim or a general protections claim, it would certainly be used against you in that you haven't executed the termination in accordance with your policy, so therefore probably harsh, unjust, unreasonable, which would result usually in a higher form of compensation being paid for being in breach of your own policy.
Yeah, look, for anyone that's gone through this process, the first step is that you go into a conciliation or mediation, where basically the employee says their version, you say your version as the employer, and then you try and negotiate a settlement. Anything that the employee or the employee representative can show that you haven't done correctly as an employer is going to work against you and force, you know, kind of push you towards trying to get some sort of settlement. So you're potentially going to have to just pay more as part of the penalty to get it settled. You know, 98% of cases get settled at that mediation stage, isn't it?
Yeah.
It's very rarely that we see things going through. Like, it does, obviously it does happen, but it's something that, you know, it's not beneficial for anyone.
No.
Court.
And I think, you know, it really does depend on I mean, the question really is in relation to the Fair Work Act violation, but you know, if you've got policies in relation to, you know, manual handling, etc., and work statements and methods, etc., that you are not following, and you have an employee who's injured, there could be an exacerbation on if the employer is liable.
Yeah.
Because they haven't followed their own
policy
and processes. Yeah. So that would be under the Fair Work, the Workplace Health and Safety jurisdiction, not the Fair Work jurisdiction. So I think, yeah, it's got the capacity to just cause you a lot of challenges, a lot of headaches, and potentially cost you a lot of money.
Yeah. So if anyone has got any questions, now's a good time to jump in and just put them in, you know, happy to answer them. Anything else that you're thinking? That we've covered all most of the things that we kind of went through.
Yeah. Look, you know, I try not to be pessimistic, but unfortunately in the line of work, I guess, that we're in, we tend to see people at their worst.
We see what goes wrong.
Yeah, we see what goes wrong. We quite often don't see what goes right. That's the bit that we miss. Look, I certainly think that 2025 is going to bring a higher emphasis on the employer's obligation to comply with things like psychosocial, managing psychosocial hazards. I think we're going to see still a lot more of, you know, the knowledge increasing of employees about where workload or where the workplace potentially is impacting their well-being, and those claims or concerns being brought to the forefront probably a little bit more readily. Look, I think that the resilience of individuals is going to play a part in how 2025 unfolds. I think there are a lot of individuals out there that are experiencing challenges from outside work influences, things like cost of living, things like, you know, being forced into living back in multi-generational homes, being forced to change their way of life, which, if their resilience is down in the outside world, it's going to infiltrate into our workplace, and the ability just to say, leave your baggage at the door, that is no longer a thing. So we need to, I guess, you know,
works work, home to home.
It just doesn't cover it.
Yeah, employees need to be proactive, and it doesn't matter if you've got one employee or you've got 100 employees. It's essentially the same. Obligations that you need, proactiveness.
My other prediction for 2025 is going to be that it's going to get harder and harder for employers not to have some form of EAP service.
Yes, yeah. So in the EAP service is an employee assistance program. So that's basically counsellors that the employer pays for, that you give them. This is a confidential conversation. Look, I don't think employers should freak out about that. If you're a large organisation, you probably sign up and get a subscription, and it does have a cost. But if you're a smaller employer, you can just like, we've had a number of small employers where we know that the staff member's going through a bit of a tough time, or even just through a performance management or performance plan improvement notice, and that they're struggling mentally with it, and we've given the option of it if they would like to take it up, and if they do, then we can just do that on an ad hoc basis. You know, it's a 50-50, almost an 80-50 probably. A lot of people they feel a bit nervous about using an employer related, even though it is confidential mental health service, but just having that offer there, I think is really important.
Yeah, and even being able to use and give employees resources on free facilities. Like inclusion of Lifeline,
Beyond Blue. Yes.
And including those into correspondence.
There should be there should be a month during the year where you kind of concentrate on that. Are you okay? These are the lines or something. You know, do some few toolbox talks and things like that. Really, I think is really important. Yeah. We've got a question here about
that's
a following on, and it's about an employee gets subjected to bullying. As a result, there's mental injury, and the code of conduct is for the employer to provide a duty of care for the employee. The employer failed to provide their duty of care, and the bullying breached the code of conduct. Look, it kind of depends upon what jurisdiction it goes through. So if they've gone through work cover and they said that they've got a mental health injury, which has been a result of work, and then it goes through to which will be covered if it's accepted and covered by Fair Work, then they will pay for the treatment, etc.
Work cover.
Well, work cover, yeah. That's what I was talking about. Did I not say work cover? Work cover. If it goes through work cover, then if there is a sustained ongoing mental health injury from it, they potentially could go for common law, in which case they could say that you failed to provide a safe workplace. So yeah, in that situation, it could be the case. If they're going through a stop bullying, to stop bullying through Fair Work, do they actually have the ability to put penalties or anything?
No,
they just have
stop bullying is a jurisdiction that has no compensation attached to it, and it's the same with the stop sexual harassment orders that they put in last year. Where an employee can lodge a claim to say, I believe I'm being bullied or harassed or sexually harassed and I want it to stop. It will be assigned to a commissioner. The commissioner will look at the information and evidence that is available, and make a determination, usually, on if it's likely that these behaviours are occurring and what mechanisms need to be put in place to prevent them occurring, or to stop the behaviour happening into the future. And that can be some change of reporting lines, all sorts of things, which the commission can enforce through a stop bullying order, but they can't force any compensation.
Compensation, yeah.
And those stop bullying claims usually only occur when the employee is still employed.
Yeah. But the workplace health and safety is the workplace health and safety work cover, definitely it can go to common law, but you also have insurance for that.
When it goes into common law, you're in the negligence field.
Yeah.
So the common law argument for if an injury was it sustained due to negligence, or was it sustained by other factors?
Yeah.
So that's where.
So an example for that is if you've got a client that comes in and they are quite violent and quite distraught, and it's really quite distressing for the staff member. Now, if you've really you can't control the clients that come in that behave that's triggered this mental health issue for the staff member. If you've done appropriate training and safety and etc., it's probably going to be hard for them to go for common law. However, if this staff member has said, hey, I don't feel safe with this people, you know, I need more training on how to handle these situations, they've been left by their own, and this incident happens, then it could potentially go into a common law scenario.
Yeah.
So look, I'm going to wrap it up now because the feedback has been that people don't like us to print for too long. I don't know why, do.
No, we're quite good at it.
Yeah, we're good. So having to go to other emails.
An email, sorry, will the presentation be recorded? Yes.
Yes, and anyone who signed up for it will send out a recording for it. So please.
You can also, I think it's going to be on YouTube. We're like YouTube sensations now.
Yeah, we've gone YouTube.
And on Facebook, and the only thing it's not on is still on TikTok, because we're not on TikTok.
Yeah. The younger generation in our office is saying we need to be on TikTok, and don't like it.
That's what a clock does.
Really?
That's it.
So
is that emphasising that generational gap?
It is emphasising that the older generational gap. So look, please, if you do have any questions, don't hesitate to reach out to either myself or Dee. Because you know she's got the answers. And we'd be happy to help you. We have actually launched an ongoing HR package. This is a great way to get all your policies, your staff handbook, your contracts, your rates, and you know, to make sure that you keep on top of things. Covers some workplace health and safety as well. So it's anyone who would like to join that or get more information, you decide to join on it, and you say that you've attended this webinar, we're happy to give you the first month free of charge. So it's only $4.40 a month, and I think it's really good value what we're giving in that package. So
because we're awesome, though.
Because we are awesome, yes.
Yes, we are.
Yes, excellent. So
look, it says you should do this more often.
So thank you very much. I hope it has been helpful, and yeah, please don't be strangers, reach out, or if there's topics or things you'd like us to cover in any of these webinars.
Yeah, give us the idea. Quite often we sit in the office here going, we think this is what people want to hear or talk about, but if there's something that we can deliver a session on for you that's going to help make your life a little bit easier, just let us know.
Let us know. Fantastic. Thanks so much.
Bye.
See you.